Joining us this evening, defense lawyer Rod Gregory, as well property rights advocate Joe Anglin. Welcome back to Alberta Primetime, both of you.
Thanks for having me.
Good to have you back. We should note as well that we invited RCMP to join this discussion, but they declined because of new federal legislation that is in the works. We will touch on that in just a moment. But Rod, is there a difference between urban and rural when we're talking about the rights of a property owner?
Well, the federal criminal code doesn't distinguish between urban and rural property owners, and the difficulty is that there's a much more immediate response in the urban areas than there are in rural areas. So it's difficult, I think, for the federal government to legislate something specific for rural property owners. Where do you draw the line? It's very clear that something has to be done.
Okay, and the federal government is looking at that. Joe, do you feel that there should be a difference in how the law treats?
No, even as a former police officer, the answer is no, there should not be a difference. What we need is to incorporate some sort of logic, some sort of common sense in the application of our laws. So when you're dealing with self-defense issues, when you're dealing with defense of property, one of the things that I think is missing, and even the new legislation I don't think touches upon that, is the perpetrator should be tasked with accepting full responsibility for creating the situation, which is generally the emotional reaction of a property owner or a homeowner. And that's an issue that most laws don't touch upon, which I think needs to be part of the calculation of, did they use reasonable force? Did they use proper mechanisms to defend themselves, which I think everyone should, we do have the right to defend ourselves and to defend property.
Joe brings up that point of reasonable force. How do you define that?
Well, Joe makes an excellent point, and in fact in the U.S. We hear about the castle doctrine, and that has to do with defending one's home. In certain states, like Joe's raising this issue, there's actually a presumption in favor of property owners when there's a break-in that they fear for the safety of their families, their property, and their lives. So there's actually a presumption in their favor in relation to their own protection. That seems to be lacking in the current proposed legislation. And reasonable force has an objective and subjective element. Lawyers and judges have trouble understanding those elements themselves, and they have to explain that to juries who have to decide whether someone is acting reasonably.
In the case of the Tabor gentleman, he was initially charged with a couple counts of assault after he took the blunt end of a hatchet to a would-be thief who was fleeing the property at the time. Those charges, though, were withdrawn, and alternative measures were used in terms of doling out punishment.
Yes.
That shows, though, then that there must be some flexibility within our justice system as it is now.
Well, I'm guessing that the prosecutor's office must have looked at the legal circumstances, and I suspect also looked at the case from a policy standpoint where they didn't want the person to have a criminal record, but they wanted some acknowledgement that perhaps he didn't act appropriately, and when he completes alternative measures, the charges are withdrawn.
I'd like to just comment on that, acting appropriately, because when you're in a courtroom, when you're in the police station, and now you're reflecting back at the circumstances, you get to evaluate everything in what I call a normal state of mind. But when you are confronted, surprisingly, with an attacker, when you are confronted with somebody breaking into your house or breaking onto your property, coming onto your property in a threatening manner, the idea that somebody's going to act rationally, in my mind, is not there. What happens is it's a reaction. You don't have time to think, and the consequences differ greatly from one person to the next. And that's why this presumption that was just spoken about in favor of the landowner, I think, has to be part of the equation. The perpetrator creates the situation, and most property owners are not trained like police officers. They're not trained like military people. They only react. and that reaction is so complex that to make some sort of a judgment call on, well, was it reasonable what they did? Well, when the adrenaline's flowing and you're fearing for your life or you're fearing for, whatever, reason has nothing to do with this. And that's a real issue when we're dealing with these situations. I think it was tremendously unjust that this one landowner had to go a whole year in the system before the finally was resolved.
Could this not be a case of where the justice system is bending to public pressure because there was a lot of support for the Tabor gentleman?
I'm not sure the prosecutor's office accounts for public opinion, but I'll say this, and I hope this complements what Joe says. The courts say that self-defense can't be measured with a nicety, accounting for the human factors that you may not act rationally at the time, but the defense of self-defense always goes back to what's reasonable. So they try to account for those emotions at the time when they're defining what's reasonable, but it's so difficult to define what's reasonable. And I represented a rural property owner, a farmer, whose house was broken into in the middle of the night. He fired a warning shot through his ceiling. The intruders still came upon him. He ultimately fired a shot. One of the individuals was struck. The property owner was charged with criminal negligence causing bodily harm. It was only when the witnesses, who were the intruders, didn't show up for the trial that the Crown ultimately stayed the charges. So when one listened to the 911 tape of this person, it was clear that they were absolutely traumatized by the incident. And then, after having been traumatized, having gone through the criminal justice system for so long, not knowing what was going to happen to them, was absolutely devastating for the person. And he still was in counseling long after the charges were finished.
So in this case, the gentleman, the homeowner, fired a weapon. If we take another scenario, say,
Yes.
where a different landowner caught the people in his or her home,
Yes.
with his firearm, made them sit and wait, no shots fired,
Yes.
until police came, would that person be treated the same as the individual who fired the gun? Or
Well,
would that
that
reasonable...
Yes. Well, that example deals with what that new legislation is talking about, that you can do certain things. I think Joe's read the legislation. You can do certain things until the police come. So I think that's what the legislation is talking about. But my client tried to get them to stop and they wouldn't. So that wouldn't apply. And it's very, very difficult for someone to react that way. And as Joe said, people aren't trained as police officers.
So now this new legislation relaxes the rules around citizens' arrest. For you, Joe, is that a step in the right direction?
You never want citizens making arrests because things can get out of control very quickly. Again, I like the idea that there's some sort of latitude given to the average citizen to restrain somebody to turn over to the police, and that is the citizen's arrest. So I think that's a step in the right direction, but I just want to go back to the whole idea of what's reasonable because it applies to both situations. If you have a gun and you're holding somebody there, and that's reasonable, but it's not reasonable if you pull the trigger, what's the point of the gun? I mean, the threat of the gun is that you could pull that trigger. To me, the logic that people are acting rationally when they are, because the initial reaction of everybody, police officers, everybody, I've looked down the barrel of a gun more than once in my life, and I can tell you the trauma that you experience from that, it takes a while to get back to a normal state of mind. And for the average person, once this happens, the circumstances are so different, so unique for everybody that I think the test of reasonableness is a very, very difficult test. So getting back to even when dealing with citizens' arrest, you really want trained people to do it. But I know fully that if somebody were to break into a home or into a store, if I have the ability to assist somebody, I like the latitude where I can restrain them or keep them until the police arrive without any threat. and this is the part that we really need to focus on. Citizens need confidence that the system works. So if I restrain somebody from stealing from this building until law enforcement arrives, I shouldn't be sitting there thinking, oh my goodness, am I going to be charged now because I just stopped this crime in the process? And we need confidence in the system. And creating these laws, they should also be thinking about creating confidence, particularly when self-defense, defense of property.
Rod, we'll give you the last word on
Sure.
this, and let's touch on vigilantism.
Sure.
Is that a legitimate concern, given all that we've discussed here
Well,
tonight?
what Joe's talking about is that applies to both urban and rural people. I don't think there's going to be vigilantism if the criminal code self-defense sections are amended. They need clarification and simplification. People aren't going out looking for trouble. If they're facing some type of break-in or invasion, they just have to have some common sense confidence that they can do the right thing, and that has to be codified by the federal government.
Well, we'll have to watch to see what the feds do with this new legislation if and when it passes. Thank you both. An engaging discussion.
Thank you.
That's defense lawyer Rod Gregory and property rights advocate Joe Anglin.